I think we're ready. So welcome everybody. Thank you for taking time out of your day to join us for this great webinar. I am JC Abu Said, CEO of Halba Hargrove, and today's session is about estate planning, and it's a core aspect of our life phase investing process. The estate planning reviews we do apply to most clients, and it's a core deliverable for the firm. Today, I'm introducing Curtis in a minute, but let me tell you a little bit about Curtis before we get started. So Curtis is a board certified specialist in estate planning, trust and probate law. He graduated with honors from UC Santa Barbara. Go Gauchos. My daughter went there, so good stuff there, Curtis. He has a law degree from Santa Clara University, where he was named Dean's Fellow and received a full merit scholarship. And if that wasn't enough, Curtis decided to get an MBA from UCLA's Anderson School of Business, where he was the commencement speaker. So without further ado, I'm going to let him take it from here. One housekeeping item is the Q&A. We want to have an interactive session with Curtis. So there's a Q&A box in your Zoom at the bottom of the screen. And he will be looking at that and trying to be dynamic with those questions. So with that, Curtis, take it away, please.
Thanks, JC. I don't think I knew your daughter was a gaucho, so that's great to know. And I don't know if when you went up to visit her, you were like my parents when they visited me back in the 90s, like, this is school? I didn't go to a school like this. So, um, so
100%.
thanks for the nice introduction. And I do really appreciate getting to speak to Halbert Hargrove colleagues, friends, and their clients. And I've appreciated the opportunity over the years to work with Halbert Hargrove because their advisors consider estate planning to be such an important part of the financial plan. And it's not just, oh, go take care of your estate plan. It's like, hey, in fact, I had a wonderful meeting with a Halbert Hargrove advisor and mutual clients earlier this week. And the level at which the advisor knew the clients, and we could have such a meaningful conversation about estate planning and how it impacted their goals and what their rate of return and their risk tolerance was and how that would affect the estate plan. It's just a wonderful, wonderful opportunity, and it's going to result in a better financial plan and estate plan. So it's good to be here to do that. I'm going to make my desk cleaner for the presentation. And so let me share my screen and we'll talk about the post-election estate planning update. And JC, if I'm not showing the presentation mode, please let me know. But the election estate planning update. Oh, and side note, not really connected to the election, but we just sent out, I was waiting till the last minute to send this out because I thought that this law might get paused or overturned. And in fact, it did get put on pause by a court today. It's just the law that you may have seen if you own any entities or businesses, that there were new reporting requirements to file starting January 1st. And those got put on hold last night or this morning by a federal judge in Texas. So if you'd been worrying or agonizing or starting to work with your CPA or business attorney about those filing requirements, you don't have to deal with them. They're on pause. But for this presentation, we are going to start with a post-election estate tax update. And then we're going to talk about the difference, in my experience, from estate planning documents versus an estate plan. And as a core piece of it, what I'm going to focus on today is my strong belief and perspective on the importance of including the family in that estate planning. So with respect to the election, the focus on the election and what we've been talking about with a lot of our more affluent clients is the potential for the currently very high estate tax exemption amount of $14 million starting at the beginning of next year to get cut in half back to an old number of 7 million. And so I'll go into those details a little bit, but first let me just kind of start with what estate tax is. And it's that the United States has a 40% transfer tax. And if you're an affluent or high net worth citizen, you're taxed on the privilege of passing your wealth. During life, it's called a gift tax. At your death, it's called an estate tax. And those gift and estate taxes used to be separated a few years ago. They were combined. And here's kind of the history or the recent history of the estate tax exemption. It wasn't that long ago that the estate tax was designed to capture more upper middle class people. You can see 20 years ago, the exemption was in the $1 to $2 million range per person. But today, or at least a month from today, 2025, we're in a happy place where affluent families, and that's per person. So for a married couple, that's doubled. Up to 14 million is exempt from that 40% transfer tax, and then that 40% transfer tax kicks in. But today in the New York Times, there was an article on the CEO of NVIDIA, Jensen Huang, who obviously is a billionaire, especially if any of you own, if any of you own NVIDIA stock. And the article was about, right, the New York Times, a little more left-leaning. The article was about how he's not paying much in estate tax because and the article was saying he's done some good planning. And that's what we'll talk a little bit about today. He gave NVIDIA stock when it wasn't worth that much to an irrevocable trust, so it doesn't count as his anymore. And if the Wall Street Journal would write the article, it would be a little more in admiration. And the New York Times writes the article, it's a little more in, hey, we need to tighten up the loopholes. And kind of that left versus right perspective ties into how we should think about the election results and whether it affects our planning or our clients' planning. So in 2025, the exemption amount per person is $14 million. Before the election, when the odds of a Republican sweep of the presidency, the House, and the Senate were pretty low, I was kind of checking Polymarket, one of those betting sites, and it said their odds of Trump winning the presidency were like close to 60%, but the odds of the presidency, the House, and the Senate, it was closer to 1 in 3. So a lot of our higher net worth clients, we were starting to plan for using up as much of the $14 million exemption as we could before it was scheduled to retreat back to a little over 7 million at the end of 2025. And it is still scheduled to revert to 7.1, 7.2 million at the end of 2025. It's still scheduled to do that. However, now that the Republicans control the presidency, House, and Senate, they can pretty much do what they want, and they would not like to see people pay more estate taxes. That's generally their position. However, they do need to proactively pass a law to change the law, because again, right now, what it says is that the exemption is going to go back to 7.1, 7.2 million or so a year from now. So they have to change it. They're not going to have too much of a problem getting the votes to that, but they are going to have a little bit of a challenge with the budget, like passing the budget. And so a couple things to think about. One, the law still says that a year from now it's going to go down to 7. And it's kind of thinking, unless you're planning to pass away in the next few years, we have to think longer term than that. We have to think, okay, well, it's going to be in this very high range, this exemption amount for the next few years. But what if we look 5, 6, 7 years out from that? How long it's going to last, and who really needs to think about this? I mentioned it's a per person exemption. So if your net worth is in these green areas, this part is not something you have to worry about. It would be a problem that you would aspire to have. As your net worth comes closer to the red areas, and it should you be thinking of this as your anticipated net worth, and if you want to use for your investable assets, if you want to use the rule of 72 and imagine that if your assets grow at 7% a year, they might double every 10 years. You shouldn't just think of what you have today, but what you might have tomorrow. And so what we're shifting with for our clients, we were initially thinking, hey, we should, for our high net worth clients, we should take advantage of this high exemption amount now. If the clients can afford to give the assets away, take advantage of the high exemption amount now because it will likely go away. Now that it's unlikely to go away so quickly, we're still moving forward with the planning, but we're doing it for smaller amounts because we're not facing a use it or lose it situation. So factors that would be in favor of gifting now for clients in this net worth plus, if the clients are younger, because the assets have more time to grow, if the clients have a high level of confidence in their adult beneficiaries or the trustees that the money will be managed properly. Factors against gifting now, the clients are not sure if they're willing to part with the assets, because when the assets are gifted away, you can't use them anymore. You can't take them back and say, I really wanted to buy a boat, I changed my mind. So if the clients would be thinking of gifting assets that would impact their lifestyle, then that's not a good gift to make. Other factors against gifting now, I don't really care if the kids pay more taxes. No, this type of planning, estate tax planning, is for people who do care if their kids would have to pay estate taxes. Most people do, but some people don't. They consciously say, hey, I don't really care if the kids have to pay more taxes. I'm not going to change anything. And if clients, let's say there was a client that was elderly and had a net worth of 30 million. Well, they're good investors, so the assets are going to grow, but we might not have to do that much gifting because estate tax planning or large gifting, because using annual gifting, an $18,000 exemption per year that doesn't count against this 14 million for the life, 18,000 per year from myself, 18,000 from my spouse to whoever we want. If we were generous enough over time, that could really put a dent in the assets. So how long is, excuse me for a sec, how long is this extension going to last? So a lot of tax commentators say maybe it's going to be a short extension. And that goes back to what I was saying about the budget. So the law says that it's going to be $7 million in a year. So if the Republicans would like to keep it at 14, they can do that, but then they have to find the money to offset that. And so in many of the articles, they're saying, well, perhaps the extension will be 3 to 5 years. 3 to 5 years at that additional bonus level of $14 million. So if you're a thoughtful, affluent person that is doing this planning, You can't just say, the Republicans won the election, they're going to want to change the law. I don't have to worry about it because in 3 to 5 years, who's going to have power? Republicans, Democrats, who knows? What's the budget situation going to be like? Who knows? So, what we're telling a lot of those clients is, hey, you were gearing up to give $14 million worth of assets to a trust for your spouse or for your kids. And now there's not as much urgency. We can still do it if you'd like to. It still makes sense. The CEO of NVIDIA wasn't doing this planning to beat the deadline. But for the clients that say, oh, it gives me a little breathing room, we're creating the structure, we're creating the trust. They're gifting a more moderate amount, a couple $1 million, sitting with that, seeing how it feels. And then we're watching what happens with the new presidency, with the new Congress. They've already said, I think the Senate Majority Leader said, we're gonna work on the border first, and then we're gonna deal with taxes. So I don't know how quickly you solve the border stuff, but it's not overnight. So there's a chance that as we get towards the second half of next year, we still don't know exactly what's going to happen with the estate tax law. And so for our clients who are at or over those exemptions, we should still be talking and having the planning, maybe setting up the trust, maybe getting ready to make gifts to the trust, just not doing it in quite as large of an amount. And feel free to ask questions in the Q&A, and JC, feel free to interrupt me to make sure that everyone's on the same page with us. And this Bloomberg headline from a couple weeks ago that just reflects what I'm saying that is happening with our clients, that we were starting to gear up to get ready to possibly make large gifts, to kind of rush to do it before the law changed. And we're telling people, let's slow down a little bit. We have a little bit more time. We can be thoughtful. So like I mentioned, we are moving forward with many of those high net worth clients. We're just doing it for smaller amounts, letting them see how it feels, feel if they're comfortable with it, because much of this planning is irrevocable. Once you give the money to the trust, you can't take it back. So better to start with a couple million and then decide you want to give more shortly after, rather than start with too much money. And kind of all of this, if you don't do anything, and you should, you're really rolling the dice on the Republicans being unified on their tax strategy, rolling the dice on that the political landscape doesn't shift at midterm elections 2 years from now. And so we're really advocates of kind of calling it like flying standby. Hey, maybe you're not geared up for using the full exemption amount, 14 million for each of the spouses, but let's put the basics in place to accomplish the main thing that these clients would be looking to accomplish, or that Jensen Huang from NVIDIA was accomplishing, is putting assets into this irrevocable trust at today's value, and using additional strategies to make today's value even smaller, and then letting the power of compounding over time make those assets grow outside the estate. And so if someone is putting in $10 million of assets today, well, let's say they end up putting in the full 14 million. They put the full 14 million in. The law changes to only allow 7 or 8 million in. And by the time the client passes, those assets are worth $20 million. Back of the envelope math, we've gotten an extra $12 million out of the estate times 40%. The family has saved $4.8 million in taxes. And that's not a crazy scenario. We can supercharge that a little bit if the parents are generous enough to use what's called a grantor trust, where they say, not only will we give away the assets, but we'll pay the income taxes on them ourselves, which allows the assets to grow tax-free and further reduces our estate by paying the taxes. See, I see something in the chat. Okay, perfect. Okay, so how should you figure out where you sit on this? I kind of think of it as 4 stages. Hey, I'm not ready to do any of this yet. It's my money. I'm still getting used to it. Just want to work on the regular estate plan that when I pass, these assets go where I want them to. Okay. Stage 2, yes, I'm interested. I'm gifting curious. I'm interested in gifting. I'd like to help my family out or loved ones, but I'm not ready to commit. Stage 3, okay, we've grown these trees, we've grown our family wealth, and we're ready to give some of the fruit from the trees, but not the trees themselves. Stage 4, we're ready to give the trees, the fruit, everything, because they're going to get it anyway someday, and we don't need it. It's not going to impact our lifestyle. Of course, these stages tend to correspond with age. The older people are, the more likely they're to advance in the stages. Net worth, the higher the net worth, more the stages. But people are in different spots. I have some clients that are very young. They kind of have a Jensen Huang mindset. Hey, they're working on a company. It's going to be big. There's a chance to save generational taxes by giving shares of the company to trust for their kids now while the company's not worth much. Let's do it. Others that are really cautious, really conservative. What if our medical costs are, in the 0.1% and they're a little more cautious? So kind of talking with your advisor, talking with your estate planning attorney, what stage are you in? If you're not ready yet, you're not ready yet. And just know that this is out there for you someday. Stage 2, this would be things like the annual gifting, $18,000 this year, $19,000 next year. Talking with your advisor about whether Roth conversions make sense, where you're prepaying the taxes and lowering your estate by reducing your taxes and then setting up the retirement accounts to be tax-free potentially for your beneficiaries. Using the annual gifting to give towards 529 college plans, possibly doing that up to 5 years at a time, which is allowed. And if you have multiple kids or grandkids, that's a way to get a significant amount of money out without a large commitment. Also, some of our clients are generous enough to make low interest loans to help family members buy property or start a business. Those have a minimum interest rate that is typically less than what you could earn on your assets. Let's say today it might be a little over 4%. So it's a better than the market rate for the kids, but mom and dad are still getting back a reasonable interest rate, and making that type of loan at the minimum interest rate doesn't eat up in the exemption amount at all. Okay, and then this for those who aren't quite ready to give more expansively to kids, one of the techniques we consider is known as a spousal lifetime access trust, and the acronym is SLAT, spousal lifetime access trust. And it's a technique by which we would use one spouse's exemption amount, today $14 million, but still allow that person to have access to the money by doing a series of things to give the money to their spouse. So you really have given it away to the spouse, so you better like that spouse and you better plan on staying with that spouse. But the idea is, yeah, you gave it away, but if you're nice to the spouse, they can still spend money on you. So that's a common strategy where they're not ready to give it to the kids, but they're ready to engage in some planning. We have to do a few steps to get there. Sometimes it's one spouse to another spouse. Sometimes it's one spouse to another spouse this year, and maybe the other spouse in a similar but distinct way back to the other spouse. You see here how in this example, I might create a trust for my spouse and our kids. And then maybe next year she might create one just for me. It can't be very reciprocal or the IRS will not appreciate it. Another version is, okay, we're willing to give the fruit or the income, but we need to keep the tree. And an example of this might be selling assets to a trust for kids and carrying back a note. There's a few flavors of this, but say again, we're carrying back the note at 4.5%, and the assets that we've given, we have confidence that they'll grow at more of a 7, 8, 9, 10% rate. And we're shifting that appreciation to the trust for the kids, but we're still taking back some income. We're not giving up all the income. We're giving up some of it, right? The spread between, say, 4 and 10%, but we're not giving all of it. And once we've decided, okay, we are motivated to minimize taxes, we don't think of the taxes just for us. We think of it kind of multi-generationally. So we're ready to give assets. When we give the assets, we're going to give the income along with it. And I mentioned it's an incredibly effective strategy, and it's what the article on NVIDIA in the New York Times today focused on, is that the CEO of NVIDIA gave these assets, NVIDIA stock, to a trust. It's grown tremendously. There's no capital gains on it, but the any taxes that are paid, he signed up to pay for the trust. So those assets are growing estate tax free, and with additional assets that he wasn't able to put in there, he sent them to a family foundation. And then the family foundation, which is required to make a 2% minimum distribution each year, is giving it to his donor advised fund. So it's kind of a masterclass article on estate planning, and that one's for billionaires, but a lot of the lessons can be applied to the merely wealthy. And when we're talking about that type of planning, we kind of think of it as three ways: squeeze, freeze, and burn. Squeeze is valuation discounts, where we have a real estate portfolio or a piece of real estate that we know is worth X, but if we give minority shares, they're not worth X. A valuation appraiser will say it's worth 80% of X, 70% of X, and we can give more assets without using our full exemption. Freeze refers to freezing the parent's net worth and shifting the growth down to the next generation. Burn is spending. There's a great estate planning saying, which is that if you don't fly first class, your kids will. So enjoy the money, spend the money responsibly. I'm a believer. I don't know if anyone's read Die with Zero by Bill Perkins, great book. And he makes a case for giving some of your kids' inheritance to them during your life. And one way to do that is through those annual gifts, the college funds, take them on a trip. But it's a lot more fun to do it during your life than when you're gone. So that'd be one form of burning. Another form of burning is using the exemption amount, right? By making the gift. And another is using that grantor trust, agreeing to pay the taxes. Charitable planning, any money that is given to charity comes off the top of the estate. So it's just an easy estate deduction. There are more creative ideas. that are very helpful. Talk to your advisor. If you are thinking of selling a highly appreciated asset, call a timeout on yourself. Talk to your advisor. Instead of paying capital gains, highly appreciated assets that you need to sell, let's say a piece of real estate, you don't want to 1031 it, consider talking to your advisor about a charitable trust and how that can help you avoid capital gains taxes, create a stream of income for you, and reduce your estate taxes. And I think we've talked quite a lot about this estate tax. So I'm going to move towards the issue of that kind of more applies generally, even if clients aren't high net worth above those estate exemptions. And it's that it's great that the CEO of NVIDIA saved billions of dollars with excellent advanced estate planning. And it's great that my affluent clients don't have to rush to give away the full exemption amount right now. But we still see when it comes time for an estate plan to be carried out, meaning someone is sick or someone has passed away, that the plans often don't work in the way that the plan creators expected them to work. And why is that? The issue is that everyone kind of knows. They've been told by the media or friends or advisors, you need an estate plan. Okay, you need a trust. Go get your trust documents. And so they're very focused. All of us are kind of very focused on getting the documents, a will, a trust, that sort of thing. And the traditional way of estate planning, in our experience, is that you get the documents. You talk to an attorney, you get the documents. They say, hey, if I pass away, everything goes to my spouse. If we both pass away, it goes to the kids. They can't have it until they're X age. This person is in charge. I have a healthcare directive. Great. I'm done. I did what everyone said that I needed to do. I have an estate plan. Everything is taken care of. But that's not really how it works. There's kind of a misconception that a living trust avoids probate. No, a living trust doesn't avoid probate. Assets that are properly titled to a living trust will avoid probate. And so in our firm about 5 years ago, we got quite tired of, at the time of crisis, when these plans needed to work, the family would come in, let's say the kids, and say, here's mom and dad's estate plan. Where do we sign? Do we get the access to the assets here? Do we drive from here down to Halbert Hargrove and pick up a check there? Do we wait? Do we have to do it tomorrow? And then I'd open the binder that they brought in, blow 12 years of dust off the binder, start to read it and say, this plan doesn't sound like it has anything to do with what your parents' life was when they passed. These assets aren't in the trust. This person's not around as a beneficiary. Nobody's talked to you about it. And things did not go how the deceased parents envisioned it, how the person carrying out the plan envisioned it. And so 5 years ago, we started adopting a different approach. We call it our legacy program, where it's ongoing, very analogous to how you work with Halbert Hargrove as your financial advisor. It's not, okay, we created an asset allocation for you. Here's your portfolio. Go get them, Tiger. No, things change. Oh, you got a new job. You got a raise. You're putting more money over here. The market's up. We're rebalancing. You're thinking of retiring. Oh, you bought a house. You want to get, things change, and they change with respect to your estate plan. There's three pillars the way we see it for your estate plan. One is the documents. You need to say basically what your game plan is. Number two, and possibly the most importantly, it's the alignment of your assets with the plan, that there needs to be a mini plan for each asset. Okay, my brokerage account with Halbert Hargrove that's custodied at, let's say, Schwab or Fidelity. Okay, is that owned by the trust? Yes, I see it on the statement. It's owned by the trust. Great, check. We do that. We do that for our clients for each asset. Oh, asset number two, it's my retirement account managed by Halbert Hargrove, custodied at Schwab or Fidelity. Okay, that's not owned by my trust, which is appropriate. I'm the owner. The primary beneficiary is my spouse. Good. The contingent beneficiary is, oh, there's no contingent beneficiary. No, 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 that's not good. Okay, the contingent beneficiary is my two kids. Oh, no, that's not good. They're 10 and 13. The contingent beneficiary is the trust. Okay, good. Next, my checking account at Farmers and Merchants Bank. It's owned by me individually. Oh, nope, that's not good. That's not going to work. Okay, it's owned by the trust. So that's the second one. First, the document. Second, the assets or my limited partnership interest. It's in the trust. And then third is over here, a family care meeting. The family needing to know what's going on. And then again, this is a process, not an event. And this was just in last week's paper. Some of you may have seen it in the news. When Warren Buffett talks, usually people listen. He's pretty wise about a lot of things. And the headline pretty much captures it. Warren Buffett talks to his kids about his will. You should too. Some of you may have heard what he mentioned as his game plan is a number of years ago. I want to give my kids enough so that they could do anything they want, but not too much that they don't have to do anything. For him, that was $10 million each. Maybe he's upped it since then, but as of 10 years ago, it was $10 million each, with the rest going to charity or family foundation. And the reason he says to talk to his family, and it's a reason I agree with, is that even if they don't like what you're doing, if you want the family to stay together, they need to hear it from you. My grandparents didn't follow that advice. It's actually kind of how I got into estate planning. They didn't talk with their daughter about the fact that they were going to treat her differently than their son, my dad. And even though we were all very close, she wasn't very good with money. She had some substance abuse challenges. They didn't want to rock the boat. They didn't tell her. And it caused tremendous problems that I don't want to burden you with on this call, but I'd be happy to tell any of you on them one-on-one. And that kind of actually sparked my interest in estate planning. I said, their documents were fine. The documents were fine. The assets, needed a little work, but the family conversation, the communication, 0 out of 10, and it led to just catastrophe. So what we encourage and do, and I had one great family meeting this week with clients and their kids who are in their 30s and 40s. And people we love to have at this meeting, trusted advisors, the backup trustee, adult beneficiaries, the plan creators. Some of our clients, we share everything. Some we only share a little bit. When I ask people, hey, let's do a family meeting, maybe now they'll be a little more receptive now that Warren Buffett's told them to have it, not just me. But typically they say, my kids don't really want to talk about it. I don't want to talk about it with them. I don't want to think about it. I don't want to disclose my assets. All normal reactions. But if we care enough to do the plan because we care enough to want to make it work, they need to know, because it's not us, creators of the plan, people on this Zoom call, who are going to be carrying out the plan. It's someone else. It's not you carrying out the plan, it's somebody else. And we cannot have that person showing up in the attorney's office and that they knew their parents had an estate plan, but this is the first time they really knew anything else about it. That they hadn't really had a good conversation with the estate planning attorney or their advisor or their CPA. They don't know what they're in for. So if we're going to trust this person with the keys to our kingdom, the trustee, we need to tell them more about the plan. The trustee is the person that's in charge of carrying out our wishes, that we trust this person to take over for us if we're incapacitated, to carry out our instructions if we're sick. They need to be at the table with us. Unless this is something they do for a living, they don't know what to do. And we need to spend more time with them on our real wishes than just telling them to be reasonable. We need to talk to them about if we have minor children, the guardians. We need to say, we give our clients worksheets and help them with prompts on how do we define what reasonable is. Because it's certain that we, the trustee, and our beneficiaries have different ideas about that because everyone has a different idea of reasonable. Uh, college, college tuition, that's pretty easy. That's pretty reasonable. Graduate school, I think most people would say yes. Helping purchase a home, some people would say absolutely. Other people would say, nobody helped me buy a home. That's not what this is for. A vacation home. Some people would say, sure. Other people would say, are you kidding me? A vacation home? No way. Um, we don't want them to hear this, to meet their professional team, to learn all this in the middle of a medical emergency or grief. So we want to have these meetings over time. We want them to learn the processes, if there has been a trust set up, an irrevocable trust, how to run this. We want this all to be done in a calm way while everything's fine and nothing's wrong. I'll share a couple survey results from affluent families. And when a plan goes wrong, here's the reasons that it most commonly go wrong. This was a study by the Williams Group of high net worth families. Only 3% of the time it's because the lawyers or the financial advisors bungled the investment advice. That's not usually the reason. 25% of the time, it's because the heirs weren't prepared to inherit that level of wealth or understand how to work with advisors. 60% of the time, breakdowns in family communication and trust. I mentioned my family issue. Well, my aunt was in grief. She'd lost her parents. So she's, I'm sure, a little mad at them, but they're not there to be mad at. Who else can she be mad at? My dad. It wasn't my dad that made the trust, but she figured it was kind of his influence because her parents never talked to her about it. So the parents, what happened was the last thing that my grandparents wanted. The last thing they wanted was any conflict. And why should there be conflict over people getting tax-free free money? But by not communicating, they kind of laid the seeds for this breakdown. Another survey question, 75% of these high net worth families said that leaving an inheritance is important to them. What percent of these same families said their kids are prepared to receive the inheritance? 20%. Quite a disconnect. So we need these families to be prepared emotionally, financially for this. Here's another statistic. If the beneficiaries weren't told about the plan, only 65% of them were satisfied with the result of their estate plan. Now, mind you, that's a very low number. This is a group of people who's getting free, tax-free money, mostly tax-free money. So the fact that they're only 65% satisfied can show you the depth of the misunderstandings or hurt or pain or grief or miscommunication. When they were told, it was 89% satisfaction, which is more like it. How do we solve that? Communication with the advisory team, with the estate planning, family meetings. And so thank you for letting me chat with you today. I think we'll turn to allow JC to follow up with any questions. And I appreciate the opportunity to chat with all of you today. Take it away, JC. Okay, let's see the Q&A. Okay. Um, do the family meetings need a witness to avoid he said, she said? Um, and I would say no. We don't need a witness because what counts is what's in the estate planning document. So the family meeting, if but your question brings up another point, which, and Warren Buffett says this too, sometimes through the family meetings, we'll realize something that we then go back and adjust the estate plan on, which is kind of part of what we do for our clients on our legacy program. We have the meeting, we think about things, we talk with the other advisory team, and then we make changes. So let's say, and this did happen in my family meeting this week, they were talking about a family vacation home and the parents thought um, that one daughter was the only daughter that was kind of interested in it. And so we had the plan set up a certain way. Then during the meeting, another child said, I might be interested in it too. And so we had an open discussion about that. And then we are going to go back to the plan and adjust it to have a mechanism to allow anyone interested to have the opportunity to keep that property on their own or together. So what counts is with what's in the trust document itself if there was a dispute. So we don't need a witness in the family meeting. We just want to have an open conversation. And we want to have, I mean, parents, you have to say no all the time. You have to say no to the candy, that sort of thing. And so you have to put your big boy and girl pants on. If you're going to need to have a difficult conversation with one of your kids or multiple of your kids, we don't necessarily need to have all the kids at the meeting. We might have a one-on-one conversation with someone who's going to be told, hey, you're going to get the same share as your siblings, but we're going to have a third party manage it for you for the moment until you can show us that you're a little bit more responsible. So I'm not saying those aren't very difficult conversations, but if we want things to go well for the next generation, we need to take the heat from our kids and kind of tell them the truth. And so I'd encourage you to Google Warren Buffett family meeting advice and see more about that. Anything else, JC?
Well, I'm hoping we get a couple more questions, but no, I really appreciate that perspective and I appreciate how dynamic that interaction can be. Fully agree with that. Chris, I had a question for you in terms of how often or what do you think it's the optimal amount of time that should pass before somebody reviews back the state plan and kind of make sure that everything is still kosher and that it's doing what you thought needed to be done?
For the clients who are on our legacy program, where they pay us an annual price and we are both reactive to them, where they call with a question, and proactive to them, where we say, hey, it's been a while, or let's have a family meeting. For those clients, if they haven't reached out sooner, we're doing what we call a biennial review. So every 2 years, we're saying, here's what we have for your assets, what has changed. Here's what we have for your plan, what has changed. Let's set up a meeting. So we do it every 2 years. And on a scale, yes, the older the clients, the higher the net worth, the more complexity of the assets in the plan, more often, and the more simple, less often. So I would say every 1 to 4 years, depending on the complexity of the family. Somebody asked how we charge for our program. We charge a flat amount based on the complexity of the client and the perspective or personality of the client. Some clients want to not dig too much into things and just have us keep them on track. Those clients pay less than those who want to really embrace and go through the details. kind of our entrepreneurs tend to want to go in and out a little more quickly than our engineer client. So it's a combination of complexity and constitution, like how much time they want to spend together. And then we mutually adjust each year. We're fortunate to have, fortunate that nearly 95% of the clients continue on that each year. The average net worth of my client base is similar to Hobart Hargrove, who their line, if I get it right, JC, is that you serve the quietly wealthy. Is that right?
Good.
And my tagline, as you can see right here, is purposeful estate planning for the multi-millionaire next door. Used to be the millionaire next door, but then inflation had to be multi-millionaire. So I'd say that the median net worth of our clients on the legacy program is probably in the $5, $6, $7, $8 million range. Another question. I have an attendee who's in their early 20s on this call. Okay, I've just got to stop and applaud for you. You're in your early 20s and you're on this estate planning call. Whoever's kid this is, that you're doing something right. That's amazing. What should you do now, if anything, to prepare for your estate planning? That just you're gonna be a huge success. I'd say work with your financial advisor, focus on your financial planning. For someone in their early 20s, I think the estate planning you need is very basic. It would be basically what we call statutory documents, which are like documents provided, you can get them from the state of California, a statutory will, a statutory power of attorney, to just say that if something crazy happened to you, here's where the assets would go. Here's who would manage things for you if you're incapacitated, a healthcare directive. So I wouldn't invest money, if, in my personal opinion, in an estate plan. If I were you, I'd get those complimentary documents from the internet, do those, take yourself from a 0 out of 10 estate plan to a 5 out of 10, work on your financial plan, and then the estate plan maybe 10 years from now. Are you on any legal plan networks? No, I'm not on any legal plan networks, unfortunately. Okay, one more question. Can we get a transcript of the call? That's up to Halbert Hargrove. And do I ever do trusts for members of the same family? I do often do estate plans for members of the same family. And the only thing I have to tell them is that it's still confidential unless we're talking about it together. So if I were to do a plan for JC and then his daughter, and we did the plan, and the original plan was his daughter was going to get her fair share, and I did a plan for his daughter, and we did that. And then JC later came and said, I'm not going to give anything to my daughter. I'd probably say, hey, if something crazy like that happens, I can't represent you both anymore. So as long as the family is not keeping secrets, then yes, we often represent multifamily members. And I haven't really done a group rate before, but I'm open to it. So there you go.
And Curtis, we will send in about a week, we will send a recording of this meeting. So for the question about can we get the script and the materials for the meeting, that's coming.
Okay, great. And then I don't know if any of your other advisors are on the call and want to chip in with 2 minutes of their own thoughts to finish us off, but I really appreciate all those good questions, and JC and your team for giving me the opportunity to share my thoughts with your community, JC.
No, absolutely, Curtis. We really appreciate 12 years of partnership. I think it's been 12 years, if not longer, that we worked
Yes.
together. So we
Yes.
appreciate that. I'm giving a little bit of time to see if we get any more questions, or if any of our crew has any additional thoughts or questions to share with the group.
And while those are coming up, couple of my favorite books that I like to recommend. One, Die with Zero by Bill Perkins. It's kind of, well, first for the gentleman in his early 20s, read The Millionaire Next Door by Stanley. That's from the 90s. And then if you're if you're a little older, then read Die with Zero. And then I'm a big fan of a book called Family Wealth by James Hughes. And his thesis is that when he talks about wealth, financial wealth is just one of the five dimensions of wealth that it's kind of the parent's job to cultivate. Other things like intellectual wealth and heritage, that a truly thriving family will be cultivating all of those forms of wealth in their family. And if you want to keep the family wealth around for multiple generations and break those that shirt sleeves to shirt sleeves curse. So those are a couple of my favorite books. And thank you so much, JC.
No, you're very welcome. Well, watching the clock, I'm not seeing more questions come in, but I really appreciate your time today, Curtis, and everybody's time. Great presentation. Looking forward to what's next. And again, thanks everyone. Thanks for joining, and we'll see you next time.
Thank you
Thanks.
so much.
Yeah.